and we have been working on it for quite some time. There were some delays, but we are keeping the pressure on to ensure that we do what is necessary to bring our water situation to something that is amenable to all. So, Madam Speaker, as you would know, water is life, and every drop counts. And the access to a reliable, sustainable water supply is fundamental to our national development in all spheres. The deployment of this advanced drone survey technology reaffirms our commitment to using modern solutions to tackle long-standing issues, of course, that predate this administration. I assure the general public that the government and this administration is working diligently to ensure that St. Kitts returns to a state where every household, every business, and our agricultural community enjoys uninterrupted access to water. May it please you, Madam Speaker.
Thank you to the Honourable Member for St. Christopher 3. Is there another presenter? Is there another statement?
Personal explanations. Motions relating to the business of the National Assembly and moved by a minister. Public business bills second reading.
I recognize the Honourable Member for St. Christopher 3.
Madam Speaker, with your leave, I rise once again to have read for a second time and lead a debate on the Anti-terrorism Amendment Bill 2025. As stated on the other paper, the Honourable Prime Minister was slated to lead this debate, but the Prime Minister has had to attend to state business overseas, and so I will fill in as best as I can to lead this debate on his behalf. And so, Madam Speaker, as St. Kitts and Nevis is a responsible partner in the international community, this bill is a vital step in our nation's ongoing commitment to ensure that St. Kitts and Nevis is never, ever used as a safe haven or a financial conduit for perpetrators or supporters of global terrorism. Madam Speaker, this bill refines our legislative framework to meet the latest obligations of the Financial Action Task Force, known as FATF, which is the global standard setter on countering money laundering, terrorist financing, and proliferation financing. Now, Madam Speaker, many will ask, what does St. Kitts and Nevis have to do with terrorism? So why is this important? Now, because FATF compliance is a determinant of a country's financial integrity, international reputation, and economic resilience, that is why we have to pay attention to these requirements at the international level. FATF sets out 40 core recommendations, which I will not go through at this moment. But this bill is designed to reinforce our implementation of Recommendation 6, which requires countries to impose targeted financial sanctions in relation to terrorism and terrorist financing. We do not want to be a conduit, we do not want to be a safe harbor, and we do not want to be listed to facilitate any of the above. So this amendment does three things, Madam Speaker. First, it empowers our authorities, of course, including the Attorney General and the FIU, the Financial Intelligence Unit, to take ex parte legal action. As an attorney, you will know what ex parte means: without notice. That is, to freeze assets without notifying the person or entity that is being investigated. And critically, this power is also extended to include those under imminent consideration for designation, not just those already listed. This means that persons who are suspected terrorists, who have suspected terrorist assets, can be frozen, their assets can be frozen without delay, as FATF requires. And why is this important? Of course, you don't want that if you suspect and you have credible evidence that there is a terrorist asset or someone facilitating a terrorist asset to get wind that you are investigating. And so this power is needed to at least freeze the asset so that the due diligence process can proceed. Secondly, Madam Speaker, the bill introduces a robust delisting mechanism allowing for correction and fairness. So for instance, where a person has died, or where an entity no longer exists, or assets no longer pose a risk, the Attorney General may formally request their removal from international sanction lists. Moreover, the public now has a pathway to request delisting through a transparent, regulated process published online. So this is a fair system. If someone was previously listed, perhaps they went through the due diligence, perhaps it is determined that they are no longer a threat or that they were never a threat in the first place, there is a process by which they can get off of the list. Thirdly, Madam Speaker, this bill refines procedural safeguards to ensure accountability and clarity in how ex parte actions and delisting procedures are undertaken. In so doing, we not only build resilience, we also demonstrate fairness and due process, cornerstones of both our democracy and international law. Madam Speaker, this amendment complements another bill that we are going to bring to this House shortly after, the Anti-proliferation bill. Together, they form a unified front in our legislative defense against all forms of terrorist and proliferation financing. Together, Madam Speaker, they signal to our international partners, to the FATF in particular, and to financial markets worldwide that St. Kitts and Nevis takes compliance seriously and that we will not tolerate any abuse of our financial system. So let me be clear. Jurisdictions that fall short of these obligations risk being placed on the FATF grey list or worse, the blacklist. Such designation brings economic isolation, reputational damage, and increased scrutiny from banks and investors. But with this bill, Madam Speaker, we take a firm step in the opposite direction towards transparency, trustworthiness, and leadership within the region. So, Madam Speaker, as this country prepares for our next mutual evaluation by the Caribbean Financial Action Task Force, or CFATF, passage of this amendment will be yet another mark of our readiness, of our integrity, and of our global citizenship. I therefore want to encourage all members of this Honorable House to support this amendment without hesitation. There is nothing I can see that is controversial about this in aligning with our international responsibilities and expectations. Our security, our economy, and our sovereignty demand no less than for us to act swiftly. Madam Speaker, with those words, may it please you.
Thank you to the Honourable Member for St. Christopher 3. I recognize the Honourable Member, the Honourable Attorney General.
Madam Speaker, I rise to second the motion. I reserve my right to speak at the end of the debate.
Is there another presenter?
Madam Speaker,
I recognize the Honourable Member. I recognize the Honourable Member for St. Christopher 7.
there is
Your mic, please.
Parliament. Madam Speaker, there is an unwelcome trend in the Parliament, and it is dangerous in terms of the duty of accountability. It cannot be the norm that the government presents bills to Parliament, and yet when the opportunity is there to elucidate, to expand, to let the public become better aware, what we are hearing are members rise to support and basically to speak if necessary. The norm, the standard norms in Parliament when members are second bills brought from the government side is that they would add to the information value that is being presented for the people. And it is really, Madam Speaker,
Two persons can be on their feet at the same time. If you're going to rise, honourable member, you have to rise on a point of order.
Yes, but I'm waiting for your acknowledgement of me rising.
You don't have to for a point of order.
I rise on a point of order.
Yes, please, honourable member for St. Christopher 3, which is his right.
Madam Speaker,
Just a second. Your mic, please. Honourable member for St. Christopher 7. Yes.
I rise on a point of order that the member from number 7 has risen to speak on something that does not pertain to the bill at hand. That is against the rules. He has no authority to dictate.
Honourable member, nobody interrupted you. Allow the member to indicate what his objection is, and then I'll respond. Everybody is going to respond in an orderly fashion. Thank you.
He has no authority to dictate who speaks on the government side on any bill. He has been given an opportunity to contribute to the bill. If he feels that information is missing, provide the information. There is plenty of time for the government side to redress any concerns he may have. I also want to add that his speech has nothing to do with the bill at hand. That is against the standing orders of this House.
Honourable member for St. Christopher 7.
Speaker, I'm making my presentation in relation to the bill and all that had transpired. I made reference to the fact that one of the reasons why it has to be highlighted because it has been a pattern, not only with this bill, but it's germane to this bill. Because on this occasion, we hear a member opposite on the government side rise to give support to the bill, and basically that's it, I second the bill. And I'm saying that that pattern is not a helpful one.
Okay.
And so that is a point of substance.
I may, honourable member.
In relation to that. And I have a right to say that because that is my view.
Honourable members, and
to make that point
honourable
in
members,
the debate.
honourable member for St. Christopher 7, I am speaking.
That in my time.
Honourable members, I am speaking. Honourable member for St. Christopher 7, whether or not you are of the view that it is the right thing to do, or whether it is the proper thing to do, it is not against the rules of this House. And so, I expect that you would move on with relevance so that we can get through this bill. Your point is taken, however, it is not contrary to the standing orders. So please allow the debate to proceed with relevance to the bill that is being debated. Thank you.
The point is taken and the relevance of it is acknowledged by the public. Because I'm making the point.
Honourable member for St. Christopher 7.
And I am therefore
the honourable member for St. Christopher 7. When I am speaking, you stop speaking. Yes. I allow you to speak. I don't interrupt you at any point in time, and so I expect you to give. Honourable member, don't be disrespectful. You are being disrespectful. You are being disrespectful. You need to cease speaking when I am speaking. That is a simple rule, and it is a clear one as well. That is not something that we're going to debate this morning. I made a ruling. I indicated that what you brought to the fore is not contrary to the standing orders. You are to move on. It is not whether it is relevant to the public. It is whether it is relevant in accordance with the rules of this House. And so we are moving on, and adhering to the standing orders. If you are not in line with that, then I will have to indicate to you that I am taking the procedures to Standing Order 49. So let us move on.
This one, Madam Speaker, is whether we want to...
Honourable member, move on. Move on and do not be disrespectful.
Madam,
I've made my ruling. It serves no purpose for you to challenge the ruling continuously. Please, move on.
Madam Speaker, I'm not challenging any rule.
Yes, you are. So please just move on.
Madam Speaker, there is an unwillingness for one to speak on matters that are germane, and in this regard, I'll say no more on this bill.
Thank you to the Honourable Member for St. Christopher 7. Is
Madam
there
Speaker.
another presenter? Very well. I recognize the Honourable Member for St. Christopher. Allow the Honourable Member to depart, and then you can proceed.
Madam Speaker, at some point in time, this House is going to have to make a decision as to whether or not it is appropriate for a member to walk in for 2 minutes, not contribute anything on the bill that is at hand, castigate the National Assembly for rules that don't exist, create grandstanding moments, only trying to evoke a response from maybe you, Madam Speaker, or members in this House. At some point, we're going to have to make a determination of how this House must proceed. It cannot be the case, and I am rising to wrap up and respond to what has been said, because that is a right that I have in the standing orders to address any issue that has been brought to the Parliament during the debate. And so I am only now responding to what the member for number 7 has introduced as part of his debate for the bill at hand. At some point, we are going to have to do something, make a determination whether it is appropriate for a member to continue to disrespect the processes of this House, seeking to cause confusion. I have sat in this Parliament now for maybe over 8 years total. And this is the first time that I have seen a member of Parliament completely disregard all of the standing traditional practices and rules of the Parliament. I cannot count more than an hour that the member from number 7 has participated in this Parliament outside of his presentation for budget. Every other Parliament that we have in this House, he comes at the very end in order to mark his name, sound his voice on radio and TV so that his supporters and maybe well-wishers can acknowledge that he was here, contributes nothing to the debate, seeks to rise up ansness where there are no ansness, only for political grandstanding. This cannot be acceptable. He speaks of following, can't be rules because there is no rule that mandates that if someone moves a debate, that someone else must speak on that. Suppose that the person is absolutely clear. What is there to add if a mover has laid out all the points before Parliament? Sometimes you have a situation where someone can be so compelling and so clear, so thorough, that the entire Parliament joins in support, says hear, hear, and move on. We gave the opportunity for the opposition members to speak before jumping up to try and wrap up. I recall in this Parliament, Madam Speaker, Madam Speaker, I am responding to what the member from number 7 said.
Yes, please,
He has said,
but I don't want it to go too far.
I understand, but I must respond. I recall in this Parliament, this is a very similar situation, where members on this side of the House, the government side, would present a bill. We would attempt on the opposition side to rise. We would stand. We will indicate to the Speaker that we intend to contribute to the bill. And you know what they did? They got the speaker then to indicate that his eye caught the member on the government side first and refused to allow the opposition to speak. That is not in the rules. That is not allowed in the rules. In fact, the rule says that the speaker must ascertain before allowing a debate to close if anybody else wishes to speak. That is what the rules say. But then, when the mover would move the bill, when they want to shut down the debate and they don't want any opposition from the opposition, the speaker will say, I caught the mover first. And no one from the opposition side was allowed to present. Those are the things that used to happen in this House. So we want to completely reject the position that the member from number 7 had. And we also want to indicate to the general public that he came in here for but 3 minutes. 3 minutes to state that we should have someone else speak on the bill when he had an opportunity to speak on the bill. This is unacceptable. And this House must at some point make a determination of how we will proceed with respect to upholding the integrity of this House. And so, given that this was the only thing presented, I also want to say that the rules also does not allow for that type of intervention for this bill. We are supposed to speak at the topic at hand. And the bill that is before us is called the Anti-terrorism Amendment Bill. Because, maybe I shouldn't say that. I won't say that. But this is the Anti-terrorism Amendment Bill where St. Kitts and Nevis is taking the progressive step, necessary step, to ensure that we protect our interests and to be responsible international partners to ensure that persons do not see St. Kitts and Nevis as a place that they can further their terrorism activities. And so I want to commend this House because everyone on the opposition side was given an opportunity to speak, and with no one indicating any further contributions, it says to me that the members of this House are satisfied that we are doing the right thing by bringing this piece of legislation before us, which is the Anti-terrorism Bill, where we identified 3 important aspects of the bill. One, of course, to empower our authorities, including the Attorney General and the FIU, to take ex parte legal action. 2, that the bill introduces a robust delisting mechanism allowing for correction and fairness. And 3, where it defines or refines procedural safeguards to ensure accountability and clarity in how ex parte actions and delisting procedures are undertaken. After that was presented, the floor was open for contributions. Unfortunately, we had an irrelevant contribution from the member from number 7, and I guarantee you that somewhere in social media, you're going to hear, I think that's relevant to his debate. But I'm responding to his, I accepted your response. Okay, all right. I am hoping that when the social media reports on this, it reports that we have taken important steps to safeguard St. Kitts and Nevis from anti-terrorism activities, and not that the House was trying to stop any member from talking, which is a possibility that might be said because that might have been the intention of the presentation by the member from number 7. So, Madam Speaker, with those few words, I want to thank the House for their support on this bill, and I look forward for it passing through this House safely. May it please you, Madam Speaker.
Thank you to the Honourable Member for St. Christopher 3, the mover of the bill who just did the wrap-up. The question is that the bill shortly entitled Anti-proliferation, Anti-terrorism, my apologies, Amendment Bill 2025 be read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill to amend the Anti-Terrorism Act, Cap 4.0102, otherwise known as the Anti-Terrorism Amendment Bill, 2025.
The bill shortly entitled Anti-terrorism Amendment Bill 2025 has been read a second time. House moves to committee stage.
Clauses 1 through 6.
The question is that clauses 1 through 6 stand part of the bill. Those in favor?
Aye.
Those against? The ayes have it.
The enacting clause.
The question is that the enacting clause stands part of the bill. Those in favor?
Aye.
Those against? The ayes have it.
The title.
The question is that the title stands part of the bill. Those in favor?
Aye.
Those against? The ayes have it. House resumes. House resumes. I recognize the honourable member for St. Christopher 3.
Madam Speaker, I rise to report that the bill entitled Anti-terrorism Amendment Bill has safely passed through committee stage without amendment, and I now move that this bill be read a third time and passed into law. May it please you, Madam Speaker.
Is there a seconder? I recognize the Honourable Attorney General.
Madam Speaker, I rise to second the motion.
Very well. The question is that the bill shortly entitled Anti-terrorism Amendment Bill 2025 be read a third time and passed into law. Those in favor?
Aye.
Those against? The ayes have it.
A bill to amend the Anti-Terrorism Act, Cap 4.02, otherwise known as the Anti-Terrorism Amendment Bill, 2025.
The bill shortly entitled Anti-terrorism Amendment Bill 2025 has been read a third time and passed into law. This is ready for the table. I recognize the honourable member for St. Christopher 3. What is happening this morning? Apologies.
Madam Speaker, with your leave, I rise once again to contribute, or rather to have read for a second time and lead the debate on the Anti-proliferation, Financing of Weapons of Mass Destruction Bill 2025. As mentioned in the Amendment Bill, what did I say? Sorry, Amendment Bill. As mentioned in the previous debate, this bill goes hand in hand with the bill that the House unanimously passed, the Anti-terrorism Amendment Bill 2025. So, Madam Speaker, this bill is really very short, very simple, but it plays a big role in protecting our country. It helps us strengthen our national security and keeps us in good standing with the international community by making sure we can act quickly and fairly when it comes to stopping the funding of dangerous weapons. At first glance, Madam Speaker, this bill might not seem like a major change or even relevant to us because we clearly do not produce any weapons of mass destruction, but it gives us two very powerful tools. First, it allows the authorities to freeze someone's money or property without warning them if it is believed that they are involved in funding weapons of mass destruction. This is important because obviously if people know ahead of time, they can then move their money and avoid being caught. And you might say, nobody in St. Kitts and Nevis would do that, but we are an international destination. We have international friends. So we want to ensure that anybody who decides to reside here, who acquires our citizenship, cannot facilitate the funding of weapons of mass destruction. In the context of counter-terrorism and anti-proliferation financing, ex parte actions typically involve freezing a person's assets or imposing restrictions swiftly and unilaterally, often based on urgent intelligence or risk assessments. FATF explicitly requires countries to have the capability to take freezing action without delay and without prior notice, making ex parte mechanisms a vital legal tool for effective sanctions implementation. So that's number one. Number two, the bill sets up a fair and clear way for someone to ask to be removed from an international sanctions list if they believe they were wrongly listed or if the reason for listing no longer applies. So this gives people an opportunity. It provides due process. The process ensures fairness, of course, allowing affected parties to seek redress and the restoration of their legal and financial standing. It is also a key compliance requirement under the FATF recommendation 6 and 7, which emphasize the need for clear, transparent, and accessible delisting procedures. Madam Speaker, the reality is that threats today can come from anywhere, absolutely anywhere, and often involve hidden financial networks. That's why acting fast and quietly is sometimes necessary, but it provides recourse for if any type of mistake might have been made. This law gives the Attorney General and the FIU, Financial Intelligence Unit, the ability to take urgent action to protect our country and meet our international obligations without waiting for a disaster to strike. At the same time, the law makes sure that people have rights, that their rights are not taken away, that there is due process, that they can clarify their position. It allows anyone who thinks they've been wrongly listed to ask for a review. And it requires that information about how to make such a request be publicly available. So everyone will then know, how can I go about asking for a review to ensure that I am not wrongly listed on any of these lists, or that my assets are wrongly frozen. This ensures our process is not only strong, but that it is fair. Madam Speaker, this is especially important because St. Kitts and Nevis will soon, as mentioned before, be reviewed by the CFATF, which is the Caribbean Financial Action Task Force. We want to make sure we pass the audit by maintaining our international requirements. The CFATF review will check if our laws meet international standards. If we don't keep up with our laws, or if we don't keep our laws up to date, Madam Speaker, you know what is the result. We risk being placed on a blacklist or a grey list, which inevitably could hurt or has the potential to hurt our economy, a potential to hurt our banks and our reputation, and that we will not stand for and we do not want. However, passing this bit of legislation, this amendment bill here today, by doing so, we show the world that we are serious about doing the right thing. Madam Speaker, this administration is building a safer, more secure, and more respected nation. We're making sure our country is protected and respected. And I want to again reach out to all members of this honorable House to support this bit of legislation. It is uncontroversial. We are open to hear any suggestions that you think we may have omitted, but I ask for the support of the entire House in the Anti-proliferation Financing of Weapons of Mass Destruction Amendment Bill 2025. May it please you, Madam Speaker.
Thank you to the Honourable Member for St. Christopher 3, the mover of the bill. I recognize the Honourable Attorney General.
Madam Speaker, I rise to second the motion. I reserve my right to speak at the end of the debate, if necessary.
Thank you, Honourable Member. Is there another presenter? Very well. I recognize the Honourable Member for St. Christopher 3.
Madam Speaker, I ensured that I sat for an extra 10 seconds to ensure that anyone wishing to contribute on this bill had the chance to do so.
Just as you did with the previous.
Just as I did
Indeed.
with the previous bill. Thank you, Madam Speaker. So I rise to, with nothing there to contend now, I rise to wrap up this debate on the Anti-proliferation Financing of Weapons of Mass Destruction Amendment Bill, which is a short bill, but significant in ensuring that we meet our international obligations as a state that is able to take decisive and swift action once we have the intelligence that there is a person of interest who we need to monitor. So with that, Madam Speaker, may it please you.
Thank you to the Honourable Member for St. Christopher 3, mover of the bill who just did the wrap-up. The question is that the bill shortly entitled Anti-proliferation, Financing of Weapons of Mass Destruction, Amendment Bill 2025 be read a second time. Those in favour? Aye. Those against? The ayes have it.
A bill to amend the Anti-proliferation, Financing of Weapons of Mass Destruction Act, Cap 4.43, otherwise known as the Anti-proliferation, Financing of Weapons of Mass Destruction Amendment Bill 2025.
The bill shortly entitled Anti-proliferation, Financing of Weapons of Mass Destruction Amendment Bill 2025 has been read a second time. House moves to committee stage. Madam Clerk?
Clauses 1 through 4.
The question is that clauses 1 through 4 stand part of the bill. Those in favour?
Aye.
Those against? The ayes have it.
The enacting clause.
The question is that the enacting clause stands part of the bill. Those in favour?
Aye.
Those against? The ayes have it.
The title.
The question is that the title stands part of the bill. Those in favour?
Aye.
Those against? The ayes have it. House resumes. I recognize the Honourable Member for St. Christopher 3.
Madam Speaker, with your leave, I rise to report that the bill entitled Anti-proliferation, Financing of Weapons of Mass Destruction Amendment Bill 2025 has passed through committee stage without amendment. And so I further move that the bill be read a third time and passed into law. May it please you, Madam Speaker.
Very well. Is there a seconder? I recognize the Honourable Attorney General.
Madam Speaker, I rise to second the motion.
The question is that the bill shortly entitled Anti-proliferation, Financing of Weapons of Mass Destruction, Amendment Bill 2025 be read a third time and passed into law. Those in favour? Aye. Those against? The ayes have it.
A bill to amend the Anti-proliferation, Financing of Weapons of Mass Destruction Act, Cap 4.43, otherwise known as the Anti-proliferation Financing of Weapons of Mass Destruction Amendment Bill 2025.
The bill shortly entitled Anti-proliferation, Financing of Weapons of Mass Destruction Amendment Bill 2025 has been read a third time and passed into law. Remember, before you present, I wish to rise briefly. House will adjourn for 5 minutes.
actually an anomaly over the past maybe decade or so where we're having this much rain at any one time. But beyond that, even when we do have that significant amount of rain, most of our rainwater does not run off, so we can't capture it like that. Most of it goes into the ground, into these aquifers, and that's the importance of today, where we're going to be sending up this piece of equipment to help identify where those aquifers are. So I want to thank the team, because this is well needed. We have spoken about it for some time. I understand, we had a few delays, but I think everything seems ready and set to go. I'm excited to see this thing take off. This is the largest drone I have seen, up close that is, in person. So I'm excited to see how it flies. And we're excited that this is going to lead to development of wells, especially in the areas outside of Bastia, because we're doing major development of a desal in Bastia, 2 million gallons per day. We found the Keon well that's producing a lot of water for us for that region. But there are other areas that need development, anywhere from outside of Bastia on both sides. And so this process is really going to help us with that. We've already in the process of lining up the drillers, so that as soon as you get your information, you tell us where that well is, we're going to go and drill it. So you have a big task, you and your team, on hand, because we have to deliver water for the people of this country, for the people of St. Kitts in particular. And I have every confidence that you guys are going to do it for us. So I want to thank the entire team, the Water Services Department, for the work that they do. So we have a lot of unsung heroes there who go into the mountains, go into the hillsides to ensure that our surface water systems are good. We have those who work with our wells, etc., to ensure that we manage our wells properly, that we're not overdrawing them to then compromise the integrity of the well. So I want to thank everyone for all the work that they do, from the manager of Water Services Department to down to the person that keeps the water office clean. This is actually an anomaly over the past maybe decade or so, where we're having this much rain at any one time. But beyond that, even when we do have that significant amount of rain, most of our rainwater does not run off, so we can't capture it like that. Most of it goes into the ground, into these aquifers, and that's the importance of today, where we're going to be sending up this piece of equipment to help identify where those aquifers are. So I want to thank the team, because this is well needed. We have spoken about it for some time. I understand, we had a few delays, but I think everything seems ready and set to go. I'm excited to see this thing take off. This is the largest drone I have seen, up close that is, in person. So I'm excited to see how it flies. And we're excited that this is going to lead to development of wells, especially in the areas outside of Bastia, because we're doing major development of a desal in Bastia, 2 million gallons per day. We found the Keon well that's producing a lot of water for us for that region. But there are other areas that need development.
House resume. I recognize the Honorable Attorney General.
May it please you, Madam Deputy Speaker, I rise to have read for a second time and lead the debate of the Proceeds of Crime and Asset Recovery Amendment Bill 2025. Madam Speaker, if you would, Madam Deputy Speaker, with your leave, if I can just provide some background to this bill. On September 18th last year, the Parliament passed the Proceeds of Crime and Asset Recovery Amendment Act, number 23 of 2024, otherwise known as POCARA. The POCARA was enacted to provide for the forfeiture or confiscation of the proceeds of crime and to make provision for persons who benefit from criminal conduct. The POCARA is premised on the ability to be able to identify, pursue, prosecute, and recover the proceeds of crime at all levels. The primary goal of the POCARA and other proceeds of crime legislation is to deter criminal activity by depriving criminals of the financial benefits derived from their unlawful activities. A robust definition of tainted property is what we changed last year, and that was in an effort to deter the engagement in illegal activities. What the POCARA also do, and what is relevant to the short amendment bill today, is that it created a forfeiture fund to consist of all monies and proceeds from the sale of property confiscated or forfeited by virtue of the POCARA, the Anti-Terrorism Act, the Drugs Prevention and Abatement of the Misuse and Abuse of Drugs Act, and the Organized Crime Prevention and Control Act, CAP 4.22, and any other relevant legislation that was prescribed by order. The fund, the forfeiture fund, is legislated to be managed by a team derived from the members of the National Anti-Money Laundering Committee and is to be comprised of the Attorney General or his or her nominee, the chairperson of the Financial Services Regulatory Commission, the head of the White Collar Crime Unit, the Eastern Caribbean Central Bank representative on the National Anti-Money Laundering Committee, and the director of the Financial Intelligence Unit. Now, that leads us into the extremely short bill before this House today. What this amendment does, and I'll read it verbatim. Amendment of Section 215. The Act is amended in Section 215 by inserting immediately after subsection 5 the following new subsection 6 as follows. 6. The composition of the team referred to in subsection 3 may be varied by order of the Minister. It's as simple as that, Madam Deputy Speaker. The forfeiture fund has certain ex officio members. It is a very important fund. Therefore, it needs to function. What this short amendment does, it allows some flexibility if there is somebody that is unable to function on the forfeiture fund committee. Therefore, by order, meaning by law, published in the Gazette, the composition of this fund, this forfeiture fund committee, can be adjusted by order. That is all the amendment does. It does one simple thing. If there is a need for expediency or flexibility to adjust the membership of the composition, membership of this forfeiture fund, then the power is with the Minister of Justice, whoever that is at the particular time, to then make that adjustment. Very, very simple, Madam Speaker. One of the shortest potential bills that you can have in Parliament, and that is all it does. It allows that flexibility so that the forfeiture fund, the management of that fund, can be done even in certain incidents where there might be someone who is not able to serve on the committee. It allows for a certain adjustment by order of the Minister. Madam Speaker, it is therefore not controversial in any way, and I therefore encourage my colleagues in this honourable House to support it so that the flexibility can be acted to the POCARA, so that the proceeds of crime legislation in this country, which has recently been updated, can function effectively so that we can deter all forms of white-collar criminal activity in the Federation. With those few words, Madam Speaker, may it please you. Madam Deputy Speaker, may it please you.
Thank you, Honorable Attorney General. I recognize the Honorable Member for St. Christopher 3.
Madam Speaker, with your leave, I rise to second the motion to have this bill read a second time and just add just a few words in support of my colleague. I want to lend full support to this Proceeds of Crime and Asset Recovery Amendment Bill. The bill, of course, as you realize, is very modest in its language, just a one-pager, but it carries significant weight in our continued fight against organized crime, financial misconduct, and corruption. This bill really serves a clear and necessary purpose to provide flexibility in the composition of the team tasked with managing the forfeiture fund. So, Madam Speaker, honorable members, as the mover of the bill recalled, in 2024, this honorable House passed the landmark Proceeds of Crime and Asset Recovery Act, or POCARA, which is, as he would have mentioned, an essential tool in our legislative arsenal to ensure that crime does not pay. The act targets the very lifeblood of criminal enterprise, the proceeds. It empowers our authorities to trace, seize, and recover assets obtained through illegal means, thus dismantling the financial structure that enables crime to thrive. So one of the key mechanisms under the POCARA, as was mentioned, is the forfeiture fund, which is a central pool of resources gathered from confiscated assets under various legislation, including the Anti-terrorism Act, the Drug Abuse Prevention Act, and others. These funds are to be used to strengthen law enforcement and crime prevention efforts. As was mentioned, at present, the management of this fund is strictly defined by statute and limited to specific individuals from the National Anti-Money Laundering Committee. Now, while the structure ensures oversight and integrity, it also creates the rigidity that perhaps can possibly impede operational efficiency. And so this amendment, all it does today is solves this problem by introducing a simple but strategic change to allow the Minister of Justice and Legal Affairs, by order, to vary the composition of the management team as may be necessary. So, Madam Speaker, this is not anything of a departure from accountability. In fact, it is an enhancement of the responsiveness of such a committee. The threats we face in the realm of financial crime are ever evolving and evolving rapidly. Our legislation must be equally agile, and that is why we are here today. So with this amendment, Madam Speaker, Madam Deputy Speaker, the Minister, whomever that may be at the time, can swiftly adjust the team to meet changing demands without compromising transparency or governance. So this really is simply about ensuring that we can act quickly and effectively, especially when matters of national security and public interests are at stake. I therefore want to support my colleague in moving this bill and commend this bill to the House and urge all of our members here to give their full support. With this, Madam Deputy Speaker, may it please you.
Thank you, Honorable Member for St. Christopher 3. Any other presentation? If not, I invite the mover. I recognize the Honorable Attorney General.
Grateful, Madam Deputy Speaker. While I wrap up on this very short bill, I just want to explain to the general public the importance of having a forfeiture fund and having it work, the committee that manages it, work effectively. So just the benefits of it. Now, what goes into the fund are proceeds of crime. So for example, somebody has committed a major white-collar crime and there's a seizure of $1 million. The state then collects that money and puts it into the forfeiture fund. But the question is, what is that fund used for? No, a forfeiture fund can actually provide dedicated financial support for law enforcement, prosecution services, financial intelligence units, and other regulatory bodies involved in investigating and prosecuting financial crimes. So in other words, the fund can be used to bolster the forces to be able to seize or to confiscate further proceeds of crime. It can also be reinvested in crime prevention. So the assets can be recovered from criminals to be reinvested in community-based crime prevention programs, victim support services, youth development and public education campaigns on anti-corruption and anti-money laundering, etc., etc. It can also incentivize and empower agencies by allowing them to benefit directly within statutory limits and oversight from the successful recovery of criminal assets. A well-regulated forfeiture fund ensures that the use of confiscated assets is transparent, traceable, and legally accountable. It also can reduce the strain on the government's budget. That money can be used for targeted programs within law enforcement. And also, FATF, which we've heard a lot about today, Financial Action Task Force, and similar international bodies view the existence and proper management of a forfeiture fund as evidence of a country's seriousness in combating financial crime. And I think that is the fundamental point. We are a modern society in a global environment, and what we are doing by these various laws, the two passed before and this, is showing that we are a responsible member of the international community that will not tolerate financial crimes within our jurisdiction. So a forfeiture fund ensures that the recovered criminal assets are not just removed from the hands of defendants, but they are strategically repurposed to strengthen justice, support victims, and deter future crimes. So as I said when I led the debate, Madam Speaker, it's a one-liner, and all it allows for is flexibility in the composition of the committee that is able to manage the forfeiture fund so that those proceeds of crime can be used in law-fighting methods to help law-fighting institutions and to show the international community that we're a responsible member and that we will not tolerate criminal activity within our jurisdiction. May it please you, Madam Deputy Speaker.
Thank you, Honourable Attorney General. The question is that the bill entitled Proceeds of Crime and Asset Recovery Amendment Bill 2025 be read a second time. Those in favour? Aye. Those against? The ayes have it.
A bill to amend the Proceeds of Crime and Asset Recovery Act, number 9 of 2020, otherwise known as the Proceeds of Crime and Asset Recovery Amendment Bill 2025.
The bill entitled Proceeds of Crime and Asset Recovery Amendment Bill 2025 has been read a second time. House moves to committee stage.
Clauses 1 through 3.
The question is that clauses 1 through 3 stand part of the bill. Those in favour? Aye. Those against? The ayes have it.
The enacting clause.
The question is that the enacting clause stands part of the bill. Those in favour? Aye. Those against? The ayes have it.
The title.
The question is that the title stands part of the bill. Those in favour? Aye. Those against? The ayes have it. House resumes. I recognize the Honourable Attorney General.
Madam Speaker, I'm happy to report that the bill has safely passed through committee stage, and I beg for it to be read a third time and passed into law.
Seconder, I recognize the Honourable Member for St. Christopher 3.
Madam Speaker, I rise to second the motion.
The question is that the bill entitled Proceeds of Crime and Asset Recovery Amendment Bill 2025 be read a third time and passed into law. Those in favour? Aye. Those against? The ayes have it.
A bill to amend the Proceeds of Crime and Asset Recovery Act, number 9 of 2020, otherwise known as the Proceeds of Crime and Asset Recovery Amendment Bill 2025.
The bill entitled Proceeds of Crime and Asset Recovery Amendment Bill 2025 has been read a third time and passed into law. I recognize the Honourable Attorney General.
May it please you, Madam Deputy Speaker, I rise to have read for a second time and lead the debate of the Extradition Bill 2025, which had its first reading on May 2nd, 2025. Madam Speaker, this bill, Madam Deputy Speaker, my apologies, is a major step forward in modernizing our justice system and protecting the good name of St. Kitts and Nevis. I want to repeat that, Madam Deputy Speaker. It is a major step forward in modernizing our justice system and protecting the good name of St. Kitts and Nevis. Let me say this clearly. Our current extradition law is outdated. It was written in 1946 when we were still under colonial rule. It is only 2 sections long, and it leans heavily on laws from the United Kingdom, specifically referencing 2 such laws which are over 150 years old. It offers no proper guidance to our police, our courts, or even our government. It does not reflect the world we live in today, in 2025. A world where crime often crosses borders and where cooperation with other countries is essential. And, Madam Deputy Speaker, most importantly, the original Extradition Act subjected us to laws passed in the UK Parliament, not ours. In other words, if the UK Parliament debated a change to the extradition laws on April 12, 2025, those changes would apply in independent St. Kitts and Nevis. We can't have that, Madam Speaker. We can't be subjected to UK laws at this day and age in our 42 years into independence. It is an opportunity for us to fix that colonial incomprehension. Now, Madam Speaker, what is extradition? It is the legal process through which one country formally requests the return of a person who is either accused of committing a serious crime or has already been convicted of a crime in that country and who is now present in another country. It is a critical tool for ensuring that individuals cannot evade justice simply by crossing a border. Extradition protects public safety by making sure that serious offenders such as murderers, traffickers, fraudsters, and terrorists are held accountable wherever they may try to hide. For example, Madam Deputy Speaker, imagine someone commits a serious offense in country A and escapes to country B. Country A can then formally ask country B to return that person so they can either stand trial or serve a prison sentence. If both countries have an agreement, or if the laws of country B allow for it, and if certain legal safeguards are in place to protect the person's rights, then the extradition can go ahead. It is to be noted that extradition usually applies to serious crimes such as murder, drug trafficking, and large-scale fraud. However, the process is not automatic. Each request is reviewed carefully by the government and the courts to ensure it meets legal requirements. There are also important protections built into the process. For example, a person cannot be extradited if the request is on the basis of political views, race, or other discriminatory reasons. In some cases, countries may also choose not to extradite their own citizens, especially if they believe the person can be fairly prosecuted or punished at home. Now, why is it important to have an extradition act that is modern and is not based on the principles that were established 150 years ago in England? Having clear, modern extradition laws is essential for St. Kitts and Nevis to be seen as a trustworthy and responsible member of the international community. Madam Speaker, I wish to re-emphasize that. It is important, given things that have happened in the past, that we regain our good name in the international community. It shows that we are committed to justice, the rule of law, and cooperation with our regional and global partners. By ensuring that our legal framework meets international standards, we send a strong message that our country will not be a safe haven for fugitives. Instead, we stand ready to assist in the fair and lawful return of persons to face justice, while also ensuring that anyone subject to extradition is treated with dignity and protected by due process. Now, Madam Speaker, if you allow me to go through part by part the bill. Part 1 tells us that the bill applies to people who are accused of or convicted of serious crimes in other countries. It explains that if someone commits a serious offense overseas, like fraud, drug trafficking, human trafficking, or murder, and tries to hide in St. Kitts or Nevis, they can be sent back to face justice in that other country. It also makes clear that if a petitioner on evasion is wrongly accused abroad, they are entitled to fair process and legal protections before any decision on extradition is made. Part 2 deals with our relationship with other CARICOM countries. This part explains how we handle extradition requests from our neighbors in CARICOM. Under the CARICOM Arrest Warrant Treaty, we already agreed to make it easier to send criminals back and forth between member countries. This bill makes that work smoothly within our local laws. So if someone commits a serious crime in Grenada or St. Lucia and hides here, or vice versa, we now have a clear path to return them. Part 3 involves returning offenders to other Commonwealth countries. The bill deals with Commonwealth countries like Canada, the UK, and Australia. This section allows us to respond to extradition requests from those countries if we have a treaty or arrangement in place. It also ensures that anyone being returned has committed an offense that would be considered serious here. Anybody being returned has committed an offense that would be considered serious here at home as well. So, for example, Madam Speaker, let's use a wild example. If in country B, it was a serious offense to pull the tail of a donkey, in St. Kitts, that would not be considered a serious offense. So if a St. Kitts Nevis national in that country B pulled the tail of a donkey and has either been charged or is threatened to be charged and they've returned to St. Kitts and Nevis, what this law does, it says it must be a serious offense here as well. And therefore, the authorities here, the court here, could decide that pulling the tail of a donkey in country B is not serious enough to then extradite that person back to another Commonwealth country. Part 4, Madam Speaker, deals with extradition to other foreign countries. This is where we cover countries like the US, Taiwan, or any other place we've signed a treaty with. The Minister of Justice has the power to officially recognize countries for extradition purposes, and any person wanted in those countries for serious crimes like terrorism, financial crimes, or trafficking can be considered for return. I want to point out we do have extradition treaties with the United States and with Taiwan, and we are in discussions to enter into extradition treaties with other countries. Part 5, Madam Deputy Speaker. What happens after a request is made? This section explains, or this part explains a step-by-step process. 1. A foreign country sends a formal request to our Minister of Justice. 2. If everything is in order, the minister gives the go-ahead. 3. The police can arrest the person even on a provisional basis if time is short. 4. The person must be brought before a magistrate within 48 hours. 5. The magistrate checks if there is enough evidence and whether the person should be committed for extradition. 6. If the person agrees to, they can consent right away. If not, they can appeal. 7. After the court's review, the minister decides whether to issue the final order for extradition. And naturally, that decision will be made in cabinet. Throughout this process, the person under threat of extradition has the right to a lawyer, to appeal, and to be treated fairly. Now, the people of this country may ask, and you may ask, Madam Deputy Speaker, what stops someone from being extradited? A person cannot be extradited under this legislation if the offense is political, not criminal, if they are targeted because of their race, religion, nationality, or political views, if they wouldn't get a fair trial in that other country, if they've already been tried for the same offense, and if the person is a citizen of St. Kitts and Nevis and the minister decides not to extradite them. But naturally, the minister must have good reason. as any public official must have good reason to take certain decisions. Now, there are other important provisions which I wish the people of this country to know about in this bill, Madam Deputy Speaker. The bill makes it clear and easier for courts to accept properly certified foreign documents like arrest warrants and convictions. If someone is arrested with stolen property or evidence, it can be handed over to the other country. If someone isn't extradited within a set time, they can apply to be released. People passing through our country while being extradited elsewhere can be held temporarily. If someone is returned to St. Kitts and Nevis, they can only be prosecuted for the crime they were returned for unless special permission is given. If a person agrees to be extradited quickly, or if a trusted country makes a straightforward request, the bill allows for a simplified process to speed things up, while still ensuring basic rights are respected. So, Madam Deputy Speaker, it's not a long bill, but it is very important because it sets out the entire extradition framework in clear, modern language. It is a bill that, 1, protects our borders, 2, protects our people, and 3, protects our reputation. If we want to be known as a sustainable island state, one that is modern, fair, and globally respected, then we must have strong, clear laws that allow us to work with our partners around the world. This bill also helps us to fight transnational crime, keep our CBI program clean from abuse, show the world that we are a reliable partner in justice and security, protect our society from those who try to use our country as a safe haven for crime. The Extradition Bill 2025, Madam Deputy Speaker, is legally necessary, morally right, and internationally responsible. It is fair, balanced, and long overdue. I therefore respectfully ask this Honourable House to pass this bill and allow St. Kitts and Nevis to stand tall on the international stage as a country that upholds justice, not just at home, but wherever justice must be served. May it please you, Madam Deputy Speaker.
Thank you, Honourable Attorney General. I recognize the Honourable Member for St. Christopher 3.
Madam Speaker, with your leave, I rise to make a brief, very brief contribution to the bill that is presently being debated before this Honourable House, and that is the Extradition Bill 2025. Now, Madam Speaker, firstly, I really want to commend the mover of the bill, the Honourable Attorney General, for leading the way in ensuring that St. Kitts and Nevis is at the top of the pile as it relates to compliance with international standards. So that is why I rise in support of this effort, because this is timely and it's essential piece of legislation that brings St. Kitts and Nevis really into proper alignment with international best practices in the administration of justice. So it must be clear, though, Madam Deputy Speaker, that this bill is not only about sending people abroad or extraditing people, but it is fundamentally about ensuring that justice knows no borders, that you can't hide, that you can't run away and find safe haven after you have done something that is against the law. At the same time, it is a bill that fiercely protects the rights and dignities of every individual. So there is a process, there is a due process, and there are ample safeguards and checks to ensure that someone is not persecuted improperly or wrongly. Now, the current legislation, as the Honorable AG would have mentioned, is based on an 1870 framework. 1870, that's 155 years ago. That is what the present framework is based on. And it's a very short piece of legislation that provides no modern avenues to properly deal with extradition cases. That's really a colonial relic, of course, that has obviously long outlived its usefulness in today's very interconnected world. We now live in a time, Madam Deputy Speaker, where criminal activity is increasingly transnational. And St. Kitts and Nevis must have the legal tools to respond accordingly. So, Madam Deputy Speaker, this act does a number of things. It is not entirely, it's not a very long act, but it is really concise and critical. It does a couple of things. It modernizes our extradition regime, replacing what would be, as I mentioned, outdated provisions, such that we now have clear and structured and rights-based framework, rights-based. So the rights of all individuals will be protected. Another thing this bill does, Madam Deputy Speaker, is that it ensures compliance with our regional and international obligations, particularly under, like what we debated earlier in this Honorable House, the CFAT-F and FAT-F regimes. An urgent matter as non-compliance can lead to grey or blacklisting with serious financial consequences. We spoke about that earlier. So it ensures our compliance so that we are not in line to be grey listed or blacklisted. A third thing that I note that this bill achieves is it strengthens collaboration with CARICOM, Commonwealth, and other treaty partners. And the Honorable AG mentioned our ongoing efforts to develop more partnerships with the international community. Therefore, allowing us to effectively deal with fugitives, with money launderers, with traffickers, and those who would otherwise exploit our jurisdiction as a safe haven. We want everybody to come to St. Kitts and Nevis to have a grand time, but we do not want anybody to bring their criminal activity here. But most importantly, Madam Deputy Speaker, is that this law, or this bill that is brought before this Honorable House, strikes what I consider a careful balance between international cooperation and the protection of human rights. I think that that is critical, and as you read through the bit of legislation, you will see the effort to ensure that human rights are protected. No person can be extradited under this act if, as the AG mentioned, there are risk of persecution, that the charges are politically motivated, or if the request violates principles of fairness and justice. The courts, of course, remain a strong checkpoint in this process. And even after the judicial review, the final decision still comes back to the requisite minister, providing additional safeguard. Because if the administration or the minister determines that a citizen of St. Kitts and Nevis or whomever, with the right reasoning, should not be extradited, that decision can still be taken. So, Madam Deputy Speaker, as I said, this will be a brief intervention. Crime has no borders, and criminals are ever evolving. They are always trying to find the next loophole to jump through. We are closing those loopholes. So crime has no borders, neither should justice. Justice should have no borders. So let us act now together to ensure that St. Kitts and Nevis is not seen as a weak link in the global fight against serious crime. Let it be known that St. Kitts and Nevis does not welcome criminals and criminal activity, and that there will be no safe harbor here for anyone involved in those types of activities. I therefore wish this bill safe passage through this Honorable House, and I encourage all of the colleagues here in Parliament to act with us as we swiftly improve our judicial improve our system to ensure that we have the best jurisdiction for preventing and not facilitating criminal activity. With those few words, Madam Deputy Speaker, may it please you.
Thank you, Honourable Member for St. Christopher 3.
I'm sorry. I don't remember if I said I second the motion, which is important.
Any other presentations? I recognize the Honourable Member for St. Christopher 6.
Madam Speaker, I rise, of course, at this time to participate in the debate in this House, debating the bill, very simply put, the Extradition Bill of 2025. And in doing so, echo the sentiments and the expressions that I'm sure would have gone before me. Unfortunately, I didn't get the full presentation of the move of the bill because I'm coming from another meeting where I was participating in an extraordinary CARICOM meeting. And so I nevertheless came in on time to lend my support to this piece of legislation. It is very instructive that the bill is before us at this time, mainly because over the years we've had very many serious debates at the level of the government with regard to extradition of persons. During the tenure of the 20-year period that I served, we've had a number of cases that were put before us by a second country that is seeking extradition of persons who are citizens of St. Kitts and Nevis. In fact, there was a period of time when this was a very critical part of our political development and one which also tested to a large extent the resolve of our country and government, of course, to practice what is enshrined within the law in terms of extradition. So this piece of legislation, which is to a large extent a bill, not really amending any other bill, because this is a bill that stands in its own right, on its own two legs. It's a new bill that speaks to the matter of extradition. And so the part one, really, which is the preliminary part, which gives it the title, the act may be cited as the Extradition Act of 2025. It gives you in section 2 of part 1 the interpretation of the act. Section 3 speaks to the application of the act. And it says here, for the purposes of this act, a person convicted of an offense in his absence shall be treated as a person accused of that offense. B, an act or omission which constitutes an offense only against military law, but not against the ordinary law of the land, shall not be treated as an offense. And 3, C, I should say, of subsection 3 speaks of every colony, dependency, and constituent part of a country, and every vessel and every aircraft of or registered in that country shall be deemed to be within the jurisdiction of and to be part of such country. Part 2 speaks to the return of offenders to CARICOM countries. And Part 3 also speaks of the return offenders to Commonwealth countries. And it outlines, of course, the designation of Commonwealth country. It outlines in Section 9 of Part 3 the extradition offenses in respect of designated Commonwealth countries. And of course, in Part 4, it speaks of existing extradition treaties or arrangements. And Part 5 speaks to the return of offenders to other foreign countries. Part 5, maybe this is Part 6, speaks of provisions applicable to return of offenders to all countries. And it gives you here in this Part 6, it says here that Section 15, powers of the minister with respect to return of offenders. And it outlines the power that the minister has with regard to persons who are to be extradited from St. Kitts and Nevis to a third foreign country. And Section 16 of that part speaks to the authority to proceed. Section 17 speaks to general restrictions on return. And Section 18 speaks to delay of return. Section 19 speaks to arrest for the purpose of committal. In other words, it gives you a comprehensive outline of how the process must be pursued in considering request of our country to another country to extradite someone from that second country to St. Kitts and Nevis, and likewise the extradition from St. Kitts and Nevis of a person who is here but needed by another country. And it goes into that kind of details. It speaks in Section 19 of the arrest for purposes of committal. In other words, the state in which the person who is requested by the requesting state, that person, the provisions are made by law for such a person to be arrested in preparation for committal. It says here, a warrant for the arrest of a person accused of an extraditable offense or alleged to be unlawfully at large after conviction of such an offense may be issued by a magistrate. A, on the receipt of an authority to proceed, most likely the authority being that of the requesting state, and B, without such authority, upon information that the said person is or is believed to be in his way to St. Christopher and Nevis. So the person doesn't have to be here, but the authority can act upon the fact that the person having been informed, the authorities having been informed that the person is on his way to St. Kitts and Nevis, and thus falls into the instructions, the law, as outlined in Section 19 of Part 6 of this piece of legislation. I'm taking this time because I think we need to understand that this is a comprehensive piece of legislation, as movers have said, and the supporters of FAR, seconder, would have said that it is ensuring that St. Kitts and Nevis is kept in line with what is expected of it as a modern state, and at the same time being part of the international community is in fact pursuing what is its obligation as an independent country within the full-blown global community that we are part of. And then Section 21 of Part 6 speaks of the duty of the court of committal to inform person committed of his rights. So even though the person is a different country, of course the court in whatever country he is being held for the necessary committal, that country must make sure that the court informs the person of what his rights are. It says here, where a person is committed to custody, the court shall inform him that he will not be returned until after the expiration of 15 days from the date of its order of committal, and that he may appeal that decision to the High Court. That is very, very important. In other words, even though the person is being held for extradition, goes through the period of trial, the person has the right still to appeal, as is given in ordinary circumstances. It speaks in section 22 of the custody of the person, and 23 speaks to appeal from order committing to custody. In fact, of course, the person may be in custody, has the right for appeal, has the right maybe to appeal against him being held or he or she being held in prison, may have the legal right to ask the court for release from prison, so that at least still in the country that is being asked to extradite him or her, and then still have the legal rights of any other person, and the rights especially as outlined in legislation which we are debating today. I'm sure that there are other countries globally who have similar laws, and so the person who's held in custody has the right of appeal, has the right also of requesting the authorities for not being held in prison during the period of waiting for extradition. And so all those are rights which are enshrined within the law, and which, as we are recognizing today, are part of our own legislation here in St. Kitts and Nevis. Appeal by Attorney General, where the decision of the magistrate is such that the return of the person requested cannot take place, the court shall, within 24 hours, transmit to the Attorney General the record of the case together with a copy of his decision, and the Attorney General may, within 3 working days from the date of the receipt of such record, appeal to the High Court by an application to be accompanied by the said record and by a copy of the decision of the Court of Committal filed in the registry of the High Court. In subsection 2 of section 24, it speaks of a copy of the application shall be served on the person whose return is requested. Subsection 3, of section 24 speaks on an appeal under this section. The provisions of section 23 shall apply mutatis mutandis, and where the High Court orders the committal to custody of the person whose return is requested, such order shall be treated for all purposes other than an appeal therefrom as an order committing such person to custody. And so usually then, before one is extradited, while you're going to the legal proceedings, etc., eventually, if the proceedings would have come to an end in terms of the rights of the person being totally exercised and would have been exhausted, then again the court has the power of holding that person again before doing what is absolutely necessary. And so it says the powers of the court. On an appeal made to the High Court, the court may, without prejudice to any other jurisdiction, order the person committed to be discharged from custody if it appears to the court that the following: A, by reason of trivial nature of the offense of which he is accused or was convicted, or by reason of the passage of time since he is alleged to have committed the offense or to have become unlawfully at large, and C, because the accusation against him or her is not made in good faith in the interest of justice. It would having regard to all the circumstances, be unjust or oppressive to return the person. So the court can order that the person be released. He is not to be extradited, as has been requested by the state that is making the request, and the person is released. Order of return to requesting country. 26. It says here, where a person is committed to await his return and is not discharged by order of the High Court or of any other competent court, the minister may, by warrant, order him to be returned to the requesting country unless the return of that person is prohibited or temporarily prohibited by Section 17 or 18, or the minister decides under this section or under Section 15 to make no such order in his or her case. So, of course, there are circumstances which would allow a person to be returned under given specific cases. It says here, a person shall not be returned to any country under this Act in any case until the expiration of the period of 15 days, beginning with the day on which the order for his committal is made. And I think I read something similar of that account earlier with regard to this. Now, in subsection 3 of section 16 under part 6, it says here, the minister may not make an order under this section in the case of any person, if it appears to the minister on the grounds mentioned in section 25 that it would be unjust or oppressive to return that person, or if he considers on any such grounds as are mentioned in section 17, and that the order ought not to be made. So I take the time for us to understand that in an extradition matter, it can be a long, drawn-out process, which to a large extent will be within the spirit of the law under which the extradition is being requested. And in our case here, in our case of the Extradition Bill of 2025, the circumstances are being laid out. But Section 27, also of Part 6, is important because it speaks to evidence. It says here, in Section 1, in any proceedings under, for the purpose of this Act, in respect of a person in custody thereunder, a document duly authenticated with which purports to set out evidence given on oath in the requesting country shall be admissible as evidence of the matters stated therein. B, a document duly authenticated which purports to have received in evidence. Oh, sorry, I forgot. Yes. And this is technical stuff, so, well, I will slow. So I'm now at Section 27, which speaks of evidence under Part 6 of the Act. And I was at subsection subsection 1B, which speaks of evidence. And it says, a document duly authenticated, which purports to have been received in evidence or to be a copy of a document so received in any proceeding in any such country, shall be admissible as evidence. And subsection 1C of Section 27, it says a document duly authenticated which certifies that a person was convicted on a date specified in the document of an offense against the law of or part of any such country shall be admissible as evidence of the fact and date of the conviction. And it goes on, Madam Speaker, to outline matters pertaining to evidence. And again, I make reference because this is not a matter that you just simply get up and pull somebody out and he's extradited. There has to be proper evidence. There has to be evidence with credibility. You have to have proven evidence to some extent. And you have to make sure that all corners of the law are met if a person is to be extradited. It speaks here of, in section 28 of part 6, handing over of property. And it outlines in this particular section that through the Commission of Police, the minister responsible may seize and hand over to the requesting country any property which may be required as evidence in that country, etc. Again, it's not only the person, but if there's evidential material that will support the case of the requesting state for extradition, then that also is handed over, is held and handed over to the authorities involving, of course, the police. It says in section 29, discharge in case of delay in returning. It says, section 29, subsection 1, if any person committed to await his return is in custody in St. Christopher Nevis under this Act, after the expiration of the following period, that is to say, and it outlines the specific cases. In any case, it says, the period of 2 months beginning with the first day on which, having regard to section 26, he could have been returned. And subsection 1b, where a warrant for his return has been issued under section 26, the period of 1 month beginning with the day on which that warrant was issued. He may apply to the High Court from the judgment of the Magistrates' Court for his defense. So it goes to the higher court. If at the ordinary Magistrate Court that request is lost, that defiance of the request is lost, then of course the higher court is appealed to accordingly. And just to say that St. Kitts and Nevis, under the previous act, from which this act I think would have gathered substance as well, we have always ensured that there is the opportunity to appeal to the higher court so that justice can be seen to have been served. Madam Speaker, Part 7 speaks of the treatment of persons who would have returned to St. Christopher and Nevis. And Part 8 speaks in a miscellaneous way of a number of things. How you remove the prisoner who is being held to and from other countries, and the enforcement of foreign punishments. Section 35 in particular speaks to the amendment of schedules. And it says that the minister by order can, in fact, amend schedules. Section 37 under this particular part speaks of transitional provisions. And then we move to the schedule, and you have schedule of offenses that are extraditable. I don't want to go through them because for the purpose of the general public, I think it's important that they be aware. Murder of any degree. So if you've been accused of murder in a state, and you are requested because you have left that state where you committed the murder, maybe, and in a state which is St. Kitts and Nevis, those authorities of the country where the murder is alleged to have been committed, that is an offense that will trigger extradition proceedings on the part of the requesting state if the extradition is being contemplated. So murder of any degree, first, second, or how many ever degrees, maybe 180 degrees, I don't know, but as many degrees of murder that qualifies, according to law, for extradition to be triggered, if possible, and has to be gone through according to the dictates of this law. Manslaughter or culpable homicide, an offense against the law relating to abortion, maliciously or willfully wounding or inflicting grievous bodily harm, illicit trafficking in drugs, illicit trafficking in firearms, assault occasioning actual bodily harm, rape, unlawful sexual intercourse with a female, indecent assault. So any of these female-related acts, for example, taking place in one country, and you flee to another country, to St. Kitts and Nevis, and you think you've gotten away, according to our law of extradition, if that state where the allegation is being made wishes to have you come to that state to answer the charge that is being put against you, these sexual offenses that I've just mentioned qualify us in St. Kitts and Nevis to consider the request for extradition. So rape, unlawful sexual intercourse with a female, notice with a female, that's kind of very incomplete, I would think. Indecent assault, procuring or trafficking in women or young persons for immoral purposes, bigamy, kidnapping, abduction, or false imprisonment, or dealing in slaves, human trafficking, stealing, abandoning, exposing, or unlawfully detaining a child, bribery, perjury, or subordination of perjury, or conspiring to defeat the course of justice, arson, or fire-raising, an offense concerning counterfeit currency, an offense against the law relating to forgery, stealing, embezzlement, fraudulent conversion, fraudulent false accounting, obtaining property or credit by false pretenses, receiving stolen property, or any other offense in respect of property involving fraud. All these qualify, according to this law, for requests of extradition to be made by a requesting state as against the receiving state. Burglary, housebreaking, or any similar offense, robbery, blackmail, or extortion by means of threats or by abuse of authority. Blackmail, important. Blackmail or extortion by means of threats or by abuse of authority. And the Attorney General specifically wants me to repeat this because I believe it is critically important. An offense against bankruptcy law or company law, malicious or willful damage to property, acts done with the intention of endangering vehicles, vessels, or aircraft, an offense against the law relating to dangerous drugs or narcotics, piracy, an offense against the law relating to dangerous drugs or narcotics. A lot of what we would have had before was related specifically to the involvement of drugs or narcotics. Piracy, revolt against the authority of the master of a ship or commander of an aircraft. It's interesting. Hijacking, whether it's an aircraft or a ship. This, again, qualifies for extradition proceedings. contravention of import or export prohibitions relating to precious stones, gold, or other precious metals, any offense under Hijacking Act, and any attempt to commit such offense, money laundering, terrorist financing, proliferation, financing of weapons of mass destruction, etc. So this is an example of what would have been identified within our legislation that would allow us as a country to consider a request for extradition based on charges which would have been laid by the requesting state, sent to our state, the receiving state, for such compliance or cooperation. So, in other words, the government, whether it is here in St. Kitts and Nevis, that is requesting a person who would have committed an offense, we will go according to this law. But if a person is here and the person is being requested by a requesting state, of course, we also would make sure that the state which is making that request does so according to our law. And if we are making that request of that state, we have to make sure that our request falls within the ambit of the laws of the requested state. But there are cases as well where a request for extradition can be made if the person is not in the state where the offense has been made, not in the state where he is a citizen of, but in a third state, not where he is, not where he's from, but from another state. Again, those requests, when they are made, have to fall within the four corners of the law. Whether it is the law of the requesting state, where then you would assume that the offense would have been committed, whether it is a request that is made of a state where the person is, which may not be in St. Kitts and Nevis, or if the person is in St. Kitts and Nevis, three different scenarios then, the law is being proceeded with at all times. So we want to assure our citizens, and we want to give assurance to citizens who may be resident here and are being requested by the requesting state for them to be extradited to answer charges, criminal charges, etc. We are going to be guided by what this law says. This piece of legislation that is before us today in this Parliament, and which becomes our Bible of guidance as to how we proceed. I therefore lend my support to this bill. Thank you.
Thank you, Honourable Member for St. Christopher 6. Any other presentation? So I invite the move of the bill to do wrap up.
Grateful, Madam Speaker, Madam Deputy Speaker. Madam Deputy Speaker, I must say, if you'll allow me to, that there could be no better presentation on a bill than by a man that has been in these hallowed halls for 36 years. I even learned more about the bill, and my team drafted it in the last half an hour than I did before today. So I must compliment the last debater, the member for St. Christopher 6, for his clear overview of all of the details in this medium-sized but important bill, and to use his words, which has now become the Bible in St. Kitts and Nevis for extradition. Madam Deputy Speaker, this is the 35th time we have been before this Parliament in the last 33 months. We have tabled 83 bills. This is the 76th debate in 35 sessions in 33 months. By any metric, this is an active parliament that is doing good for the people of St. Kitts and Nevis. So I want to say, while I'm wrapping up, that our people should not be confused about what we're doing in this honorable house. We're doing it for them. And people should not be distracted by persons who have been here for less than a third of the time, have debated no more, and probably much less than 10 of those 76 debates. Don't be distracted by that. Focus on the hard work that is being done in these chambers, that we're doing for you. And I say that to say, sometimes the general public feels that we come in here and we have fancy debates and it doesn't impact them. But I want to point out, Madam Speaker, in my wrap-up, why this bill matters. What this bill does, it creates a modern extradition regime that anybody can take up, go on our website and see, and say, St. Kitts and Nevis has a modern extradition regime. We therefore, the deduction from that is that we have strong anti-crime laws and will not tolerate being a safe haven for criminals of any nature. And what does that do? It allows those persons who look at our laws to say, but St. Kitts and Nevis seems like a place where the rule of law is dominant, and therefore we would like to invest in that country. No strong anti-crime laws, no foreign direct investment. No foreign direct investment, no new jobs, Madam Deputy Speaker. This type of bill allows us to be a responsible member of the international community to create an environment in which persons are willing to bring their money for the benefit of the 53,000 of us who reside in these two islands. Also, what this bill does, it creates a stronger anti-money laundering, counter-terrorist financing regime. Without strong laws in relation to those matters, Madam Deputy Speaker, we will have no correspondent banking. We will be blacklisted, grey-listed, and cut off from the international financial market. If we're cut off from the international financial market, you cannot receive money through normal banking from your friends and family and other financial supporters throughout the world. And also, no one will do business or bring their foreign investment into our country. I say that because the laws that we pass today, and it's no coincidence, Madam Deputy Speaker, that all four of the bills debated today overlap somewhat. Because we've decided when we schedule Parliament that we don't want to be over here and over there and over there and over there to confuse our people. We want to bring clusters of bills that are similar in nature so that we don't take the minds of persons all over the place. We have a central focus today. Anti-money laundering, counter-terrorist financing, ensuring that money in St. Kitts and Nevis isn't used for the financing of weapons of mass destruction. It doesn't get into the hands of terrorists, that it can be seized through the Proceeds of Crime Act, and that if there are actors who wish to hide in St. Kitts or Nevis, there is a strong extradition regime by which they could be brought to justice anywhere in the world. So I wanted to wrap up by saying this bill makes sense. It is our new Bible for extradition, and it has been 150 years in the making. Because the bill that is being repealed and it's being replaced today references extradition acts from the UK from 1870 and 1873. We now have our own rules. We are not controlled or guided by persons sitting in Parliament in London. This Parliament has come today to say, this is our Bible for extradition, and these are the rules which are fair, provide due process, and allows our authorities to take matters of extradition through the various stages in order for us to be a responsible member of the international community. And I therefore implore all the members of this House to support this bill and to establish today in this honorable House a new Bible for extradition. May it please you, Madam Deputy Speaker.
Thank you, Honorable Attorney General. The question is that the bill entitled Extradition Bill 2025 be read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill to make provision for the extradition to and from other countries of persons accused or convicted offences and for related matters, otherwise known as the Extradition Bill 2025.
The bill entitled Extradition Bill 2025 has been read a second time. House moves to committee stage.
Clauses 1 to 38.
The question is that clauses 1
schedule, Madam Chair, but that is not necessarily 38. That is the schedule. But I don't know if the schedule is read separately. Yes, so I will
Okay.
we'll raise that issue when schedule is read.
Okay.
Clauses 1 to 38.
The question is that clauses 1 to 38 stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
The first schedule.
The question is that the first...
Yes. Sorry, Madam Chair. We wish to propose an amendment of number 9 in the extraditable offences list in this first schedule. The first schedule should actually read first schedule, so that is the first amendment. It should be first schedule. And the second amendment is to section 9, which says unlawful sexual intercourse with a female. It should be unlawful sexual intercourse only. Yes. And so 9 should read, it currently reads unlawful sexual intercourse with a female. It should read unlawful sexual intercourse, full stop. And section 11, which reads procuring or trafficking in women or young persons, it should be procuring or trafficking in people for immoral purposes. So remove women or young people in people or young persons. I should actually in persons. Trafficking in persons is the language that normally is used. So it should be procuring or trafficking in persons for immoral purposes. Yes, so we're taking out women or young persons and also the comma. So it should be procuring, comma, or trafficking in, well, yeah, the comma should remain, comma, persons for immoral purposes. Yes, please, Madam Chair.
The question is that the proposed amendments for the first schedule stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
The second schedule.
The question is that the second schedule stands part of the bill. Those in favor? Aye. Those against? The ayes have it.
The enacting clause.
The question is that the enacting clause stands part of the bill. Those in favor? Aye. Those against? The ayes have it.
The title.
The question is that the title stands part of the bill. Those in favor? Aye. Those against? The ayes have it. House resumes. I recognize the Honorable Attorney General.
Madam Speaker, Madam Deputy Speaker, I rise to report that the bill shortly titled the Extradition Bill 2025 has passed through committee stage with amendments. And I now move that it be read a third time and passed into law.
I recognize the honourable member for St. Christopher 4.
Madam Speaker, I rise to second that motion.
Thank you. The question is that the bill entitled Extradition Bill 2025 be read a third time and passed into law. Those in favour? Aye. Those in favour? Aye. Those against? The ayes have it.
A bill to make provision for the extradition to and from other countries of persons accused or convicted of offences and for related matters, otherwise known as the Extradition Bill 2025.
The bill entitled Extradition Bill 2025 has been read third time and passed into law. Next item on the order paper.
Motions, resolutions, adjournment.
I recognize the Honourable Senator Joya Clark.
Madam Deputy Speaker, on the adjournment, kindly allow me to bring to the attention of this Honourable House the note that the government of St. Kitts and Nevis, as we announced some couple months ago in our budget address, will be hosting the Global Sustainable Island Summit starting on Sunday with 2 days of our Island Youth Forum. We expect to have over 120-something youth from across St. Kitts and Nevis joining us at the St. Kitts Marriott Hotel, plus youth internationally. On Monday as well, we will be hosting the Geothermal Forum that would be co-hosted by Minister Maynard, member for number 3, and Premier Bransley in Nevis in partnership with Nevlec and Skelec. And on Tuesday 27th to the 29th, we will have 3 days of plenary sessions at the St. Kitts Marriott Resort. We have guest speakers from all across the world, over 200 plus delegates from as far as the Pacific, including Marshall Islands and Palau, heads of ministries of environment across the Caribbean, as well as technical agencies, including United Nations agencies, etc., regionally and internationally, to participate in this summit. Importantly, on Tuesday evening, we will be launching our Sustainable Island State Agenda to the world, and we will be having our Sustainability Spotlight and Media launch, and we welcome NGOs, heads of organizations, institutions, financial and otherwise, have all been invited to participate in all of these activities. It's going to be a great, most productive session for St. Kitts and Nevis, an opportunity for us to deliberate and speak, really dialogue with the rest of the world and island nations about the challenges and opportunities in sustainability. Thank you, Madam Deputy.
Thank you, Honourable Senator Clark. I recognize the Honourable Member for St. Christopher 3.
Madam Speaker, Madam Deputy Speaker, my apologies. With your leave, I rise on the occasion of the adjournment to firstly congratulate the Ministry of Sustainable Development here in the Federation of St. Kitts and Nevis for this extraordinary conference, Sustainability Summit, that is taking place right here in the beautiful Twin Island Federation of St. Kitts and Nevis. This is no small undertaking. It has been in the works for months. Hundreds of delegates and participants from across the globe, from as far as a plane can fly, to here will be part of this particular summit. And this summit is effectively the Sustainable Island Island Summit, or the Global Sustainable Island Summit, is about taking action for island sustainability. And as we officially launch our Sustainable Island State Agenda, we are showcasing to the world the tremendous work that we have been doing to establish St. Kitts and Nevis as the most sustainable island, most sustainable island state in the globe. And so from water and food security to climate resilience and geothermal energy, this summit helps all to discover how islands such as ours are leading the way in sustainable development, how we are exploring innovative solutions and collaborating on strategies for a thriving island future. And so I want you to pay attention to the outcomes of this summit. This is where partnerships are developed and concretized, and this will put St. Kitts and Nevis further in the front on becoming a sustainable island state agenda. It would be my privilege to lend my full support to these activities by the Minister of Sustainable Development and the Cabinet as a whole, as the administration is intent on achieving our sustainable island state agenda goals. So I want to commend the tremendous amount of work that has been done. I've been speaking with stakeholders from across the globe, and I'm having meetings. Many of them have told me how excited they are to be traveling to St. Kitts, and many of them want to finalize a number of the very important partnerships that we have been working on, and so we look forward to that. Many of the ministers will be in action, showcasing our progressive agenda to move forward. With that, Madam Deputy Speaker, I also want to take this opportunity to congratulate I think we did already, but the month of May is a very exciting month for the St. Kitts Nevis Labour Party, and there were a number of successful events that have taken place over the month of May, including marching in solidarity with our workers on the first Monday of May, as we do traditionally every May. But in addition to that, our political organization goes to conference in the month of May to decide our agenda for the upcoming year, and in this case, the upcoming 2 years. And so I want to take this opportunity to publicly congratulate our party leader, who was elected once again to serve as our leader. That is our Prime Minister, the member for constituency number 8, the Honorable Dr. Terence Drew, as he was returned as the leader. And it is, I also want to congratulate, of course, sorry? Yes, unopposed, of course. He was elected unopposed, meaning he got nominated from all of our branches to continue as leader. And likewise, the Deputy Prime Minister, Honorable Dr. Jeffrey Hanley, member of constituency number 1, and myself as the other deputy political leaders also returned the confidence of our conference with nominations from all the branches, and we were also returned unopposed. So congratulations to my colleague, and congratulations to the new executive of the St. Kitts Nevis Labour Party. The party is what forms the agenda and gives this administration the mandate on how we should govern. It is, at the end of the day, we have been set here or sent here on a political agenda to achieve political milestones on behalf of all the people of St. Kitts and Nevis. And we take our guidance from the root of our party, the masses of the people, and so we want to thank them ever so grandly here for giving us this mandate and for their continued support. The conference was held this last Sunday. It went very, very well. I have gotten a lot of reviews about it. And if the Prime Minister was here, a message that people are telling me to give the Prime Minister is maybe he should start getting ready to call in school? That's what they're telling me, but that's up to the Prime Minister. And that's within his remit. So I want to congratulate the St. Kitts Nevis Labour Party movement for continuing on this 93-year-old mission to do the good that we can do. With that, Madam Deputy Speaker, I want to move a motion that this House stands adjourned, signed, dying.
Seconder. I recognize the Honourable Member for St. Christopher One.
Madam Deputy Speaker, I second the motion.
Thank you. The question is that this Honourable House stands adjourned. Sign it aye. Those in favour? Aye. Those against? This Honourable House stands adjourned.
Good day. Hi. Okay.
Take the second flight of the drone just to demonstrate how it operates. What we have over here in this rack is a sensor for measuring electromagnetic signatures as well as magnetic signatures. And then the drone will fly in parallel traverses every 50 meters apart, about 50 meters high,
Okay.
to